All right, let's jump right into this explainer. Today, we're demystifying the high-stakes world of legal ethics and looking exactly at how your rights are strictly protected under the law. We're pulling directly from the regulations governing the South African legal profession to unpack a concept that is absolutely fundamental to justice, but honestly, often misunderstood: conflicts of interest.
We've got 5 key areas on the agenda today: defining a legal conflict, the duty of loyalty, 3 types of conflicts, enforcing the rules, and we'll wrap up with the golden rule. Let's get to it.
Starting off with Section 1, defining a legal conflict, or what I like to call the referee dilemma.
Think about this for a second. Would you trust a soccer referee who is blowing the whistle in a match where his literal own brother is playing on the field? I mean, no way, right? Even if that ref manages to call a perfectly fair game, everyone watching is going to naturally suspect some kind of bias. And that perfectly captures the essence of a legal conflict. It's about the perception of fairness just as much as the reality of it.
So, bringing this exact idea into the courtroom, a conflict of interest happens when an attorney's personal interests, or their duties to another client, directly clash with their duty to act in your best interest. In South Africa, the Legal Practice Council, or the LPC, doesn't mess around with this. They have a code of conduct that strictly regulates these clashes. They don't just suggest you avoid them, they actively police them to protect the public and ensure the absolute integrity of the system.
Moving right along to Section 2, the duty of loyalty. This is really the baseline of trust.
You know, you really can't fully grasp what a conflict is until you understand this core concept: fiduciary duty. As a legal practitioner, you owe your client a fiduciary duty. That basically means a relationship of absolute trust, total honesty, and unwavering loyalty. We are talking about the absolute highest standard of care in the professional world. You are entrusting this person with your livelihood, your freedom, or your finances, and the law demands they treat that trust with total reverence. This duty really boils down to 3 absolute musts. 1, an attorney has to put your interests above their own. 2, your interests come before any third parties. And 3, they have to maintain strict confidentiality. No exceptions. So the crucial takeaway here is that a conflict of interest is born the exact second anything threatens to crack any of those 3 pillars. The moment loyalty is split, the duty is breached.
All right, Section 3, 3 types of conflicts and how that loyalty actually gets compromised in the real world.
There are basically 3 disastrous ways this can play out. First up is a concurrent conflict. Think of this as a client versus client clash. This is when the same attorney, or even different attorneys working in the exact same law firm, try to represent 2 people whose interests are totally at odds. Imagine a buyer and a seller fighting over a property sale. You literally can't aggressively fight to get the lowest price for the buyer while simultaneously trying to squeeze out the highest price for the seller. It's just practically impossible.
Then we have the second type, which is a successive conflict. This is a former client versus current client scenario. This kicks in when taking on a new client means an attorney has to use confidential info they got from an old client, or worse, if they have to directly attack the legal work they literally just finished doing for that old client.
To put that into perspective, imagine a lawyer defended a client in a really messy, sensitive divorce a few years back. During that case, they learn all about the client's hidden financial assets. Well, that attorney absolutely cannot turn around later and represent that person's business partner in a brand new lawsuit against them. Why? Because they've got inside info. Using that hidden knowledge would totally prejudice the former client. That loyalty from the past case actually survives into the present.
And the third type is a personal conflict, attorney versus client. This happens when a lawyer's own wallet, their private business ventures, or their personal relationships start clouding their objective legal advice.
Picture this. A client comes to a lawyer wanting to sell a piece of land, and the lawyer realizes, wow, this land is massively undervalued. Instead of doing their job and getting the highest possible price for the client on the open market, the lawyer secretly buys it themselves through a private shell company for cheap. Their personal desire to snag a bargain totally conflicts with their professional duty to the client. It's a massive ethical violation.
So, faced with those 3 dangers, concurrent, successive, and personal conflicts, how does the system actually protect you? Section 4, enforcing the rules, the LPC protocol.
The Legal Practice Council demands a really strict 3-step protocol that practitioners have to follow. Step 1, identify it early. Law firms are required to run extensive database conflict checks before they even touch a new file. Step 2, disclose immediately. If a red flag pops up, they have to tell the client right away, openly and transparently. And Step 3, decline or withdraw.
In the vast majority of cases, the attorney just has to say no to the job, or if the conflict pops up mid-case, they have to formally step away.
Now, there is one super rare exception to this rule called informed consent, but it only applies to very limited, non-contentious scenarios. For example, if two parties just need a basic contract drafted and they already agree on literally every single term, an attorney might be allowed to act for both of them. But, and this is a massive but, they need explicit, written, fully informed consent from both clients before a single pen touches paper.
But here's the kicker. Even with that consent, the safety nets stay up. If a fight suddenly breaks out later on over that exact same contract, the attorney can't just pick a side. They are forced to withdraw completely from helping either party. They have to wash their hands of the whole thing to maintain the integrity of the process.
Which brings us to the ultimate safeguard of the South African legal profession. Section 5, the Golden Rule, the ultimate ethical test.
The guiding star for all of this is pretty simple. If there is a reasonable risk that you cannot give your client 100% unbiased, independent legal advice, you have a conflict of interest and must step away. The standard isn't mostly independent, it is 100%. If there is even a tiny reasonable risk to that standard, the attorney's got to walk. The protection of trust is absolute.
Knowing just how fiercely the system guards your trust and how deeply these fiduciary duties run, it kind of changes how you look at legal representation, doesn't it? So the next time you find yourself needing legal help, stepping into an attorney's office to hand over your most sensitive problems, will you remember to ask exactly who else they're fighting for? Think about that for a bit. Thanks for tuning into this explainer, and we'll catch you next time.